Hey, everybody. That was quick. Hey, just a couple minutes. Thanks to everybody that joined me on my previous stream with Ricky Hill and his daughter Jasmine. And here I was going to be all raging about what I know, what I've seen about this brief. And yet now that was so emotional, such an emotional little chat. And so I really want to thank them for coming on. If you missed it, go back and watch. I think Jasmine is such an amazing young lady. Pretty much had to raise herself, and yet managed to go to get her degree, her bachelor's degree in nursing. And she's now working, doing some advocacy work, and so I just think it's amazing what she's doing as well. So at least I have some people here already. You guys are in the chat, and yet it's not showing up. Oh, there we go. I have 12 people. Yeah, I make a cocktail. I should have grabbed something to drink. So, okay, so here's the deal. I'm so angry. I can't say I'm surprised about anything that I've read so far. I feel like I don't even have to read the rest of it because I already know where it's going. But as everybody knows, like I have problems with dizziness, and I was reading, and I was having trouble comprehending because I was so dizzy, and then my head started hurting, and I was like, yeah, this isn't going to happen today. But I still had plenty to say about those first 15 pages, and I just want to talk about some things specifically about how this brief demonstrates everything that is wrong with our post-conviction system, our post-conviction procedures. And Wisconsin, what they've done is demonstrated how little they care about the truth, about actually investigating what really happened, how much little they care about Teresa, how little they care about anything other than Steve and Avery is just a really bad guy, and he should be in prison. That it's literally like all they have to go on. Again, from what I've read, I see three arguments being made: procedural bar, conclusory allegations or assertions, and insufficient pleading. That's it. And those are all procedural mechanisms. They're all procedural issues. I didn't see anything so far about the merits of the case. I don't know if I will, if anybody wants to come on and talk that has read the whole thing. But are you going to address the merits of anything, or are you going to continue to stand on these platitudes and ignore the fact that completely ignore the truth-seeking function of our courts, or of which is supposed to be in our justice system? You're supposed to want to get to the truth. And the procedural bar is a technicality. Now, here's the thing that really drives me crazy. And I had this so much better in my head, and I'm already getting all jumbled. But from a legal standpoint, a lot of what the state is saying is not wrong, unfortunately. Oh, God, I hate that. But it is so not in the spirit of the law. It's not in the spirit of the law at all. They're basically saying, well, who cares? Who cares about all the evidence you found? Who cares about all these inconsistencies you found? Who cares about all this stuff? It doesn't matter because he's procedurally barred from presenting it. Why? Why is that the issue? Why are we ever deciding somebody's freedom on procedure? It is just ridiculous to me. And this is what's wrong. It's like legally they're right, but then we need to fix the law because it's ridiculous. At one point, I know they said something about how Steve is trying to relitigate his trial and how you can't oh gosh, a collateral review is not about attacking the verdict. It's about constitutional issues. They're saying you're trying to attack the verdict. And then they put, well, 12 jurors already found him guilty. So end of story there. Well, if that's the case, then why do we have over 2,000 exonerees that we know of? They were all convicted by 12 people too, beyond a reasonable doubt. They are actually sticking their head in the sand again, and they're pretending like there are no problems. Just like when Fallon said at Brendan's trial that, innocent people don't confess. Really? I mean, this is what your justice is like? This is what your truth-seeking capabilities are like? It's just that, I'm not saying they're right about everything, because they've conveniently left out things. And again, I haven't read everything, but I know there's one thing for sure that really stood out to me. And I actually had to drag out one of my video notes from previously. They're arguing that Steve did not give sufficient reason for why he could not have presented this information in a prior post-conviction petition. And this is why, if you watch the previous interview, why I asked Ricky, and I believe why Travis was getting this too, is that what Travis, after reading the Henley decision. Yeah, exactly. Henley is a great example of how little they care about justice. It's ridiculous. But their argument about the hood latch was very interesting. Yeah, I haven't gotten that far, other than just saying that was a conclusory statement about the hood latch, which it is. I mean, Casey doesn't have proof that's what happened. She can't prove that it was. She's just saying that, based on what, the testing and things that were done, that it could not, she does not believe it could have come from a hood latch. Anyway, I totally lost my train of thought now again already. I gotta stop looking at the chat. You know how this is what happens to me. I said there was one thing that I knew. I said some video notes. They said that Steve did not provide sufficient reason as to why he couldn't present the claims earlier. And this really angers me, because this is exactly one of the biggest problems that I had with the judge's original denial. Because she said that Casey, in the petition, that Casey made no argument or showing of sufficient reason, when clearly she did. She listed the reasons, and the state is even listing them. They're saying that he's indigent, he doesn't have the legal knowledge, he doesn't have, access to whatever the information that he needs to properly defend himself. And then the state goes on to argue that, well, there's no case law that suggests that being a pro se petitioner is sufficient reason. First off, about that, I pointed out, I'd actually written about this, is back when I first talked about the original decision. I said that Casey did offer reasons as to why they weren't previously raised, and she also listed case law to go with it. And in order to evaluate the issue correctly, the judge should have discussed the reasons given in the petition, and then provided her reasons as to why they did not amount to a sufficient showing. Well, that's exactly what the state is doing here. It's like they realize that's a big problem in that decision. So they're going to give the judge a hint and be like, this is something that you should have mentioned if you in your order. You just said that he didn't say anything. He didn't mention any reasons, and that's not true. He didn't offer any arguments or case law. Again, not true. So again, it's like the state, the judge helped the state out with their arguments, especially when it came to the computer issue and the CD issue, when she determined, and especially with the bones issue, when they determined that there was no bad faith for the state, without requiring them to have to give any explanation as to why they did what they did. She decided that there was no bad faith. So the judge is helping them out. They're helping her out by now putting this type of thing in the brief, so that she can make sure not to screw that up the next time she rules. And then again, this is talking about a real big problem in the system. And this is why I asked Ricky about it. It was that pro se litigants have no chance, practically no chance at all. Ricky's a pretty intelligent guy, and he understood. He said he understood the legal issues pretty well, and he couldn't make a decent argument to help himself. So Steve certainly wasn't able to. And this is what really gets me, is that they said there's no case law, nothing suggesting that that lack of legal knowledge is a sufficient reason to file a successive petition for post-conviction relief. Well, in the judge's decision on Steve's pro se motion, she essentially says that Steve doesn't know his ass from his elbow when it comes to the law, She's like, you make no like coherent arguments. Your arguments have nothing to do with the legal standing. You either misconstrued or misunderstood or misstated the law. Your conclusions completely made no sense whatsoever. And this is the same judge. So how can you sit there and say that there's nothing saying that not having legal knowledge is a reason to not be able to or to be able to file another petition when her own order said that very thing. Basically said, Steve, you're an idiot when it comes to the law and nothing you filed made sense. So we're just going to throw the whole thing out. So that's the fact. That's the problem that is showing, or that's the proof that he did not have the legal acumen to be able to file these claims. But they're ignoring certain things about investigating. State versus Thiel. I talked a lot about that. A lot on Steve's case is going to depend on State versus Thiel. They mentioned it on page 7 with regards to IAC, but they forgot the most important parts of Thiel. Not forgot, but they've neglected to mention it. And I looked in the table of contents, and I see no other place where there's no other place where they mention Thiel. Thiel is the kind of the benchmark ruling on ineffective assistance of counsel in Wisconsin, and it's under Thiel that says that defense attorneys have a duty to investigate. And so when they're talking about the state's talking about just because Steve didn't have, experts or anything, that doesn't matter. Well, according to Thiel, it can matter. It's actually State versus Render where they actually said, since the new expert completely contradicted what the previous expert said at trial, it was considered newly discovered evidence. And then it went so far to say that under those circumstances, it is required that they should get a Mockner hearing, which is an evidentiary hearing for IAC claims. They should get a Mockner hearing because the attorneys need to be able to give their reasoning for why they did what they did. That's why you need to have a hearing. So you've got a bunch of case law actually saying that you need to have a hearing for these things to find out why they didn't investigate. The other thing Thiel covers is the ineffective assistance of counsel when it comes to being negligent in pre-trial discovery and going through discovery and missing things. Well, hello, what do you think the CD was and the DCI report on that? That was not carefully going through pre-trial discovery. They had the information, but they missed it. They missed it. You can't, and again, that's exactly what Thiel says. It says that it's ineffective assistance of counsel if your lawyers, it's basically they're not giving you sufficient counsel if they do not properly read through and understand all the discovery materials. And then the third thing under Thiel is that IAC claims can be cumulative. You don't have to win on one specific claim, but when you look at them as a whole, then you can overturn a conviction based on the totality of all of the claims together. It doesn't have to be one claim. Those are things that they didn't mention at all, not surprisingly. But I was kind of surprised. I thought they would, and then they would just say, well, procedurally barred. He's procedurally barred for bringing it up. Why didn't he bring it up before? I am just so tired of seeing the state going on and on about all the reasons why he shouldn't be able to make these claims, why he shouldn't be able to present these issues. They obviously mentioned quite a bit about the piecemeal way that the post-conviction petition was put together. Well, this is a really unique case, and you have to make allowances for the unexpected and for a situation that nobody else has ever had before. First off, the statute allows for supplemental motions. Okay, it's in the statute right there. Why do they have a motion, or why do they have a statute that says you can supplement your motion, your post-conviction motion, if it's not allowed, which is what the state keeps trying to say. It's not allowed. They are treating it like it was successive petitions. No, it was all still part of the same petition. These were supplements that are added to the original petition. They were, at no time were they ever trying to file an additional petition. Yet the state keeps trying to wanting to make it look like they did. And again, as far as I know, there's nothing in the statute that says that you have to have a certain time frame. I mean, even the Court of Appeals allowed them, remanded the case back to the circuit court to get to the bottom of these issues. And can Steve claim IAC on himself? Well, they were going after the Postconviction Council, and I don't know if they cover this in there, because one of the other mistakes that the stupid judge made was that she said that KZ improperly filed the IAC claims and that they should have been a Postconviction Council. Well, she said appellate counsel, and that they should have been filed as a night petition in the Court of Appeals. A night petition is an ineffective assistance of counsel claim against your appellate attorneys. Yes, that has to be filed in the Court of Appeals. Okay, that's actually our habeas corpus statute, the state habeas corpus statute, part of it. What KZ was filing was ineffective assistance of counsel of post-conviction counsel. They're not the same thing. Post-conviction counsel properly needs to be filed in the circuit court, which is what she did. And yet the judges are saying, "Oh, this was improperly filed in the wrong court." No, it's not, you idiot. It was very clear in the filing that she's saying this is ineffective assistance of counsel of his post-conviction. I mean, they were appellate attorneys, but they were serving in a post-conviction capacity. Yeah, I say that they state. Travis just said that they cited Thiel one time. Yeah, when it suited their argument, but the crux of Thiel, which is all the important stuff, they don't even mention at all. Yeah, and Eric Jose is saying that Steve is unique because the case file was immense. Yes, but the biggest problem is that Steve, again, is this issue with pro se appeals. Nobody should be able to be procedurally barred because of a pro se petition. Again, this is something that is so wrong about our legal system, because it's penalizing you for being poor. It is penalizing you for not having the money. And this is why I brought it up to Ricky. I said, how many of those petitions were either public defenders or pro se? And the first 3 were, and he was denied. And yeah, he got denied 8 times, even with the Innocence Project working for him. But eventually he won. And statistically, I would really like to know. I would like to know what the statistics are in that. How many exonerees filed pro se petitions that were denied and then later got competent counsel and then their convictions were overturned? I would really like to know the stats on that, because I have to believe that it's going to be a pretty high number. And so to say that, well, Steve is he's procedurally barred, then why do we have a post-conviction process? I completely understand the need for finality. I understand why they have the law. In most cases, it's understandable, because you don't want people to be able to just file an endless stream of ridiculous, frivolous lawsuits. I mean, or petitions for relief. But knowing what they know about wrongful convictions, there has to be some allowance made, especially when it comes to these pro se petitions. Why are you being penalized for advocating for yourself, especially when you're serving a life, as Steve says, a life bid? Why are you being penalized? Your only option, like Ricky was saying, this was his last chance. He was exonerated on his last appeal. Steve was at that point. Making a Murder had not come out. He had no reason to think it was ever going to come out. He did not have Kathleen Zellner as an attorney. He didn't have anybody as an attorney. He's going to be in for life. He has very little hope. So he did the only thing he could do, and that is try to advocate for himself. And he is getting punished for it. And again, where is the justice in that? There is none. You're punished by having a public defender to begin with, and then later when you have to be pro se, how can you possibly think that a pro se petitioner would have a chance of even trying to get a decent claim? And the state says something about how well, you're still expected to make a sound legal argument and claim. And I was like, oh, shut up. I just like, again, where is the truth-seeking mechanism in our justice system? Because there's nothing that I've seen so far, and I'm only in 15 pages. What the hell did they talk about for the next 115 pages? Because it seems like it's going to be more of the same. Couldn't you have just written like he's procedurally barred and he should stay in prison? Because that's literally like all you're saying. And I'm probably going to skim through the rest of it eventually. But I was so angry over how they're completely ignoring the merits. Yeah, and how can you fight the conviction if you don't even have access to all the evidence? How can you fight a conviction when you don't have money, when you don't have investigators, when you don't have money for these experts? I mean, and then to say that there's no factual claims being made. All of the testing are factual claims. Those are the facts. Now, like I said, if the judge is going to say they're insufficient, reasoning, that's fine, but that's not what was said. They're just completely ignoring what they don't want to draw attention to and hoping that it's good enough. It's good enough. Never at any time has the state filed anything on the merits. And, I guess you guys have to let me know if they did in this one, or I'll find out eventually. But so far, it doesn't seem like it. So again, how is this just? How is this in the interest of justice? That you're going to sit there and say that, well, he can't file any of these claims. It doesn't matter if he's right. It doesn't matter if he received ineffective assistance of counsel. It doesn't matter if there were Brady violations. It doesn't matter that his constitutional rights were violated over and over again. It doesn't matter because he should have filed it earlier. And that's what happened in the Henley case as well. And Henley, it was there. I've talked about it before, but there were 3 different people that were arrested for this crime, and one was tried, and then it was a mistrial. They didn't retry him again, so he got off completely. The other 2 went to prison. One of them was exonerated by the 7th Circuit, and the other one, he was not allowed to file his petition for a writ of habeas corpus because he missed the deadline by a week. And it was the same arguments for both. And one guy was exonerated and the other one had a service sentence. And so, like, again, where is the justice in that? And it's the same type of thing here where they're saying, like, we really don't care. We don't care about all of this stuff you found. You can't relitigate this case. And that's it. The jury said, he's innocent or guilty. These are constitutional claims, and you have provided insufficient reason as to why you deserve to have another chance at this. Let's see what I'm trying to do. There was a lot of repeats. Yeah, well, that's just lawyers in general. Sorry, Travis, but yeah, lawyers repeat things way too much. Well, at least I understood the first 15 pages. Yeah, but it made me angry because I could see where it was going. It just shows that, once again, there is absolutely no interest in justice in this case. And it is a big problem for them to say that the jury found him guilty and that should stand at all costs. That's right. End of story. You don't get another chance. Then you are completely turning a blind eye to all the wrongful convictions that have happened, that have happened. It's their complete failure to even acknowledge that maybe they made a mistake. And in the fact that they've already ignored in just this short little time, they've already ignored case law. No, this is not the last word on the case. KZ has 15 days to reply. Now she can only reply to what is actually in this brief. So she can't come up with anything new or anything. She can reply specifically to the issues that they brought up in this case, which is a lot of it's going to be things that I'm talking about right now. She's going to give them. She's going to again explain what the reasons are for why he did not previously address these issues. And but again, when you talk about just straight legal issues. So the state's going to get away with it. That's the sad part. They're going to get away with it because legally they're not wrong. It's just not a matter. It's a matter of what is right. Here, I'll put up the question. So do you see the state's motion as strong or weak? It's the first 15 minutes are strong from a legal standpoint. If you want to stand on procedure, that was probably the best bet for them. So in that respect, yes. But weak as far as as actually caring about justice, weak as far as actually caring at all about what actually happened to Teresa Halbach, weak about actually caring at all about evidence and questions and things that don't add up and potential corruption. And so in that response, it's completely weak. It's completely weak. But that's the thing. They don't have to have a strong argument when they can stand on procedural bar. Does Casey get the final word? Yes. The reply is the last thing, the state, but then they'll decide if they want to have oral arguments. And one of the other things they talk about is how there is no case law that will say that, that you can, pro se litigants have to be treated differently, or should get treated differently or everything. Well, the problem is, again, we're talking about pro se litigation. How many of those cases ever get published? They're usually per curiam opinions that are from the bench that never get published. So of course, there's not going to be a lot of case law on pro se litigants because they don't get very far. And the few pro se ones that I have seen have been unpublished opinions that the Court of Appeals has actually still overturned. And Eric Jose, you're right. Yeah, they did not seem impressed last time that they argued primarily procedural bar. And I hope that the court will see things differently. At some time, somebody has to take a stand against how unfair this is. You should not be able to say that, too bad, you shouldn't get a second chance because you didn't get it all right the first time. And so therefore you should stay in prison. You should stay in prison despite the fact there are so many problems with this case. You shouldn't be able to say that. And unfortunately, under the law, they can. But the law needs to be changed. And I don't know if the court is going to be wanting to go out on a limb on this one to do that. Yeah, and on the issue of a young blood vibe, I would tell everybody, I mean, everyone wants to hear like, oh, this is garbage and blah, 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 and it's like, well, it is, but it's also not. It's not like just like anything else that we've had them throw at us. It's garbage as far as that, they're not addressing the merits. But from a legal standpoint, I said they're probably going to get away with it. I would tell anybody, like, don't be overly optimistic. To us, it looks crazy and it looks like, how can this happen? But Steve's chances are like so slim to begin with. And when they're going to sit there and basically just thumb their nose at the law, at the law, I mean, at the justice system, it's not just, that they're finding loopholes, which they are, but it's like you're completely thumbing your nose at the justice system. That they definitely aren't trying to see it operate the way that it's supposed to. They are just trying to find a way to keep Steve in prison. And that's why I said that their argument might as well have been, he's procedurally barred and he shouldn't be getting out of prison because we say so. That's the extent of how strong their arguments are. Did she ever argue prosecutorial? She dropped everything with Ken Kratz and the ethical issues, so that was all dropped. That's why they made a point of saying that, well, there's several issues now that aren't even in the appeal anymore, so we're not going to address that. And what he's referring to are those things that were in the original petition, like the ethical issues and things like that against Kratz, the brain fingerprinting. And she kept those out of the appeal. She ended up not pursuing them. So that's why they said they weren't going to address those issues. If anyone else has any specific questions, just go ahead and ask, because I'm just rambling at this point. I'm saying the same thing over and over, and I know I've already forgotten things I wanted to say. I'm actually going to browse through can you see if I can find anything else while you guys are thinking there. If you have any questions you want to ask. If it's something I haven't seen yet, just go ahead and ask anyway, and I'll try to remember. But again, I can't really remember my case law. I can't So I can't really do a deep dive. I'm just doing things I remembered, and I did an entire video on Thiel, which is why I knew exactly. I mean, I still had to look it up to get my details right, but I mean, I knew Thiel was the case I wanted to look for, so that's a plus. Or at least I remembered that much. Oh, them with all their issues are presented. Blah 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 blah. Yeah, they are in Maryland, so they're kind of snarky. They are snarky about things, like in the footnotes, especially. On page 15, which is the last page I read, this is when I stopped. I got to the footnote, and now I can't remember what it said, but I know it irritated me. And that's why I was like, I'm done for now. When they said Avery has made the same error in regard to all of his claims, not just the claims he raised in his June 2017 motion. And I couldn't even find the stupid, like, the footnote of what they were referring to by that. I just didn't care at that point. So they're basically saying the whole thing is just garbage, and he's made the same mistake over and over, and I'm assuming it has to do with procedural bar. But again, same thing with Allen. State versus Allen is, yeah, KZ is hinging a lot on State versus Allen. And, but again, they're completely dismissing it, completely, even though she did offer the who, what, where, when, why, how, all that stuff. But they're just completely ignoring it. And I know that one of the things that in Allen is also the IAC issues, because here I have it here. The post-conviction court must hold a Mockner hearing. Again, that's a hearing on an IAC claim. If the defendant's motion on its face alleges sufficient material facts that, if true, would entitle the defendant to relief. So again, they're ignoring the fact that if they're true and they're standing on procedural bar, instead of saying that they must hold a Mockner hearing. And it says it is and it's called Mockner hearing based on the case State versus Mockner, where they said it's a prerequisite to appellate review of an IAC claim that the challenged attorney explain his or her actions at a post-conviction evidentiary hearing. It's prerequisite to appellate review that these attorneys explain their actions. You can't guess. And that's what this judge loves to do. She loves to guess on by saying it was trial strategy without them actually saying that it was trial strategy. She's guessing that. She likes to guess on a lot of things because, she doesn't really care about facts a whole lot. And then what else was there? There's something else I know that really stood out to me and I already forgot it. So are there any other questions? They don't mention lollipops. Yeah, I haven't obviously gotten that far into the actual. Do they actually discuss the actual results of the experiments, the scientific testing? And I would say that I still have higher hopes with the Court of Appeals than I did with Judge S. That's for sure, because they've actually proven every decision that they've made has actually been pretty fair. So I mean, granted, they haven't really had to rule on a lot, but even with just the remanding it back a couple times to the circuit court for proper evaluation on the claims that supposedly the state says they shouldn't have been allowed to do, but I guess more than the Court of Appeals does, because why would they remand it and say you can put this in a supplemental motion if they can't? Because that's what the state's trying to say, that they couldn't do that. They shouldn't have been able to do that. You're halfway through. Yeah. I just, yeah, I'm going to go through it. Now I am going to go on with Julie and Fenn from 80 More Things. I'm going to go on with them on Saturday night, I believe. We're also going to have Travis on, so he can help me with the legal stuff, because obviously my brain's kind of all jumbled and it's hard for me to talk about the legal stuff, even though I want to. It's killing me to not be able to go and look up all this stuff, but I know I won't remember it, and it would just give me a headache. So Travis is going to be on too, and I'm just going to be there kind of hopefully after I've looked into it more. But Julian and Fenn have said that they're actually going to be presenting KZ's argument from the original brief, or the appellate brief, and then do a presentation with the state's rebuttal like next to it, so that you can really compare what she said versus what they're saying. And I'm looking forward to seeing that, because I need to go back. Well, I actually never read Casey's appellate brief, so I can't say reread it because I never read it to begin with. I just didn't feel like I needed to, because I already knew what all the arguments were going to be. I knew nothing new was going to be in there. So, and Casey's made all these arguments already, so she was just compiling them into one brief. And the state we haven't really heard from before, so I was hoping they would give us a little more substance, but they didn't. But I'm not surprised. After the Bones issue and them standing on procedural bar, I am not even a little bit surprised that they use this tactic. Not even a little bit surprised. It's just, just don't ever say that you actually care about justice and you care about the truth, because that brief is directly in opposition to that goal. Yeah, Casey anticipated these procedural arguments. Yeah, and I could have too. That's what I think I said then. I said, this is going to be what she's going to say. This is what the state's going to say. Because, yeah, you pretty much know they only have, this is the only argument they have is procedural bar. That's like the only thing they have to stand on. And they're going to stand on that mountain until they die. They're going to live and die on that procedural bar mountain. Yeah, that's it. And again, that's where I have issues with, like, you can't call this a justice system. Any chance of, let's see, there was much discussion about black letter law judges and judges who would consider aspects such as legislative intent, natural justice. Yeah, you can put Wisconsin firmly in the black letter law judges. Once in a while, you see things, veer off. But this is why you can predict what judges are going to rule, especially when it comes to the state Supreme Court and SCOTUS. I could predict exactly who was going to rule what in Brendan's case, and there was only one judge that I was a little bit in the air about. But the rest, I knew exactly how they were going to rule. And you shouldn't be able to know that. You shouldn't know how they're going to rule. And you do, because they follow a certain, ideology that's very clear. Yeah, nothing's going to happen with EDPA. I fail to believe anything will ever change with EDPA. It'd be nice, but I just don't think it'll ever happen. States won't allow it. They would fight tooth and nail for that one. Yeah, there was a lot of stuff on Bobby's computer that they had on that CD. And again, that's when the judge essentially made the argument for the state without asking for input from them that what was it? Oh, God, I totally lost. Never mind. But the defense obviously didn't get to have a hearing and say how they missed that, why they missed that. The judge decided that it was trial strategy without even asking. I was thinking about the Bones issue. The Bones issue, she decided that there was no bad faith, even though she never asked the L.E. Wiegert and company and Fallon, who or what their intention was, why they got rid of them. She never asked, and yet she put in her order that there was no bad faith. Yeah, this is in front of a 3-panel judge, just like, but this is in state court, not in federal court. So it's still here in Madison. Now, I've said this before, but for people who don't remember or haven't watched me in a while, oral arguments are not a given in state court, not like they are in federal court. They're actually very rare in the Court of Appeals. Supreme Court, yes, you have oral arguments, but for the Court of Appeals, it is rare to have oral arguments, very rare. So, but there's a lot of issues in this case, and so I would really hope that at least, I will know that the court is at least being open-minded if they have oral arguments. That's at least a good sign that they are being open-minded. They want to hear more on these issues. They're not going to just stand on procedural bar and that's it. Because if they're going to stand on procedural bar, there's no point in having oral arguments. Could the Court of Appeals have a say if they think it was in bad faith? No, because that's not what they do. They just are reviewing the lower court's decision. They're not making any judgments on their own about that. They can say like that the judge should not have made that determination without a hearing. That's what they can say. but they can't say anything specifically about whether there's bad faith or not. Well, technically, I guess they could if they wanted to, but usually they'll say that you need to remand this for a hearing on this issue. And remember, that's where we are in this process. I know it's already been really long. Obviously, it's taken so long to get to this point, but we are still in the process of just trying to get a hearing. We are not even talking about them overturning Steve's conviction at this point. We're still ways away from that. We are just trying to get a hearing, and then once they have a hearing, the circuit court can deny him again, and then we go through the appellate process all over again based on the ruling after the evidentiary hearing. So the hope is, so from this standpoint, I think there's hope because I do think there's a lot of reasons to grant that evidentiary hearing, which would remand it back to the circuit court. This is not going to be an issue that is decided about whether his conviction should be overturned or not. That's not what they're going to be deciding. They're going to be deciding whether he should get a hearing or not. And that stinks because it took 2 years or 3 years in appellate court just to get this response, and then we have to start the whole thing over again. Because it doesn't matter who wins if there's a hearing. It doesn't matter if they overturn his conviction or if his conviction's upheld. They're gonna, whatever side loses is gonna appeal it. So that's where we are. And I always hate to be the bearer of bad news, but I want people to understand where we're at and manage expectations. Like, do not think that you're going to get a response from the Court of Appeals that says that, yes, his conviction is going to be overturned. Could they do that? Yeah, but they won't. They will never do that without a hearing. There's no way they would do that without a hearing. And technically they shouldn't. I mean, we would like that because, be nice, but technically, just like the circuit court should have ordered a hearing, they should order a hearing. You can't get to the bottom of some of these things without having a hearing. Yeah, it is. Did you look up the stats, the recent stats? Travis, I haven't looked in a year, but he said there have been 17 criminal court of appeals decisions this year. All of them were no oral argument. When I first looked it up, there'd only been like 2 in the last 3 years. So it's definitely not like the federal courts where it's something that you automatically do. But if it goes to the Supreme Court, which, let's face it, it probably won't. But if it did, then there would be oral arguments. Yeah, I think Steve's case has had enough publicity in the media. I don't think the media is going to help at this point anymore. I just don't think it's going to do anything. This is all in the hands of the court. We have certainly made a lot of noise over the last 4 years. Steve's, case has been obviously 2 documentaries or, docuseries, whatever you want to call them. Just an endless amount of media attention. It's not going to change anything. That's what I've always said from the beginning. As I said, that we aren't going to get him out by media. We're not. And in general, we shouldn't want that. Because in most cases, we don't want a trial by media. We want people to get a fair trial. And that goes both ways, So you have to say somebody that you think is guilty should get a fair trial. If you want people to say that somebody that's innocent should get a fair trial. You have to have both. Yeah, that once the Court of Appeals remands it back for a hearing, then they can get rid of Judge Sakevich or whatever, how you say her name. Yeah, then they get rid of her. So that's why if the Court of Appeals remands it for a hearing, which I think there's a good chance they will do. So in that respect, I think there's a good chance. I'm just saying that overall on these claims, just don't get too crazy optimistic about it because, I don't want anyone to be disappointed. I would say, hope for the best, expect the worst. I don't know. I mean, that sounds bad, but you really have to manage your expectations when it comes to this stuff because, like I said, what Ricky just said, he lost 11 times before he won. Steve is not close to 11 yet. Not even close. He was in for 23 years, so yeah, it can take a while. Do I feel like she gets past procedural bar? I think if the court wants to do the right thing, she should. But by the letter of the law, it's going to be hard to get past it. And this is why, I said in the beginning, and I know Travis is going to agree with me, and people just don't hate, because it's just a fact that it would have been better for Kathleen to to file a motion with the Court of Appeals asking to amend his pro se motion and then file all the claims, as opposed to dismissing that and filing a new petition for post-conviction relief. That's really what is the big problem. Don't hate on me, it's just a fact. So I'm sure she wishes she had done that too at this point. There was something else I was going to say about that too. I just thought of it and then I lost it again right away. Hate my brain right now. No, we don't really know why the AAGs have all left. We have no idea. We like to think it's because they're scared, but really, like, why would the state be scared? I mean, that's what I always tell people. We think they should be, but realistically, why should they be scared? There's absolutely nothing saying that they have anything to be worried about. So, I mean, that's why I don't see anybody. It would be nice to think that somebody has some moral, or has, morality issues and ethical issues about this case, and that they wouldn't want to be on it. But I don't think that that's something that, we can assume happened at all. Might be totally different reasons. Lawyers get moved from case to case all the time. Will it be a request to ask remove judge? Yeah, well, she can file a request. The Court of Appeals could just automatically order it, but if not, then she can just file a request asking for a new judge. Brady violations, there's never a high chance of winning a Brady violation, just like there's never a high chance of winning an IAC claim, because there's always a loophole. There's always a way to get around everything in the law, and that is the problem. And that, to me, is what completely undermines the idea of justice, is because you can get past those things. Yeah, it's an ineffective assistance of counsel claim, but when it comes to like the prejudice prong, like, you have to prove or provide sufficient reason as to why you think that if this information had been presented at trial, it would have changed the verdict. Well, nobody's a mind reader. You can't say for sure what would happen, but for some reason the court is very subjective in the fact that they say that, well, no, we think that even if this had been presented, there was enough other evidence of his guilt that it wouldn't have mattered. And that's why I feel is very important on this cumulative issue when it comes to IAC claims. And I think right now what Casey is really kind of hoping is that somebody is willing to go out on a limb, as far as the Court of Appeals, that they're willing to go out on a limb and say that, he's not procedurally barred because there was sufficient reason, whether it be because of the experts or something else. I mean, and I can tell you right now, Casey does not think she's going to win all of these arguments. She doesn't. She only has to win one. That's it. She has to win one claim. And just because she filed like 70 of them, she certainly doesn't expect to win all of them. She probably thinks she's going to lose most of them. And a lot of her arguments were flimsy on some of them because, you really just can't get around that. And that's just her might as well throw it in. But she definitely had weaker arguments on some things. And I don't think anything of it, because every attorney can't win on everything. It's just the way it works. Yeah, they say that a lot about how things were just speculative. And that's what I talk about when they say conclusory assertions, is that it's just stating that you're not supporting facts. When they talk about the procedural bar issue, what they're saying is that when they're saying it was insufficiently pled, what they said is that essentially you need something fact-based to prove that Steve did not have the legal acumen to be able to properly defend himself. Now, we all know how well that worked for Brendan, in a confession, that he had an IEP that said he struggles with language and doesn't understand, he takes things very literally when they're only meant figuratively. So he doesn't understand that, truth will set you free is an idiomatic language. Brendan has an IEP, that specifically says he has trouble with idioms, and it didn't matter. So they're saying that you need some proof that Steve doesn't have the legal acumen to do this, but how do you get proof of that? And that's why I said the closest thing to proof is the fact that in this judge's previous decision, she basically called Steve a legal idiot. Casey did too, actually, in the brief. She basically said Steve's clueless and doesn't know what he's talking about. That's why he should get another chance. And she had to argue that. No offense to Steve, but I mean, she had to argue that. And it's kind of funny when you think about it, because it's like, okay, you're totally throwing bus here, but she had to argue that basically, it comes to the law, he doesn't know what he's talking about. And trust me, Steve thinks he does. He doesn't. We had many conversations about that. And they want to say, like, okay, if it was a pro se litigant, show the facts that show his that the reasons why being a pro se litigant hindered him. And again, well, what can you say other than what she said? That he can't hire investigators, he doesn't have the money for it. They mentioned that he's indigent. Again, what proof are you supposed to show? It's a well-known fact he's indigent. If he wouldn't be filing pro se if he wasn't indigent. So some of those things, it just seem like they're so common sense, but they're going to let them get away with saying you didn't give us sufficient reason, even though those are all really good reasons as to why that pro se petition should not act as procedural bar. But there's no case law supporting that. Yeah, Brendan did have an IEP. Yeah, and an IEP just stating very clear as day that he had problems with language and understanding certain things, and didn't matter. They still determined he understood it, and it was voluntary. And so this is what I'm talking about. Like it's very demeaning and not demeaning, defeating. That's what I'm thinking of. It's very defeating that even when you make a logical, sound argument, they still can just say, nope, it's not. You might think it is, but no, it's not. That doesn't count. The system is not designed for the imprisoned to win. Everything is stacked in the favor of the state. Brendan's team stepped in at his first post-conviction proceeding, actually. Yeah, immediately after trial, they stepped in. So they were both the post-conviction and appellate lawyers, but they were not the trial lawyers. And Maureen, 15 months is actually kind of quick. We talked about that with Ricky. I think it was him that, was it Ricky? Oh gosh, got him all. That is something like 4 years, took 4 years before his petition to get approved. Jennifer, there is definitely nothing about common sense that is in the law. No, there's no room for common sense in the law. None. So there was, I don't know what they do with themselves. Judges should rule with common sense. They should, but they don't. And that's why I said you get letter of law people, you get spirit of the law judges, and most of the time you kind of want to, in this position, you really want to have someone that's kind of along with the spirit of the law. It's like the law shouldn't be that even if you find evidence of possible innocence, that you can deny somebody on procedure. That shouldn't be the case. That is what my main rant is tonight, is that should not be the case. And it is. And until that changes, the wrongfully convicted especially are always going to be fighting a losing battle. There are going to be a very few who are going to be able to prove their innocence because it's not stacked in their favor. And all of these guys who've been in for 15 years, 23 years, the guy that was in for 40 years, whatever, all of them have had the procedural bar issue come up because they've obviously filed an appeal right after their trial. So they've all had this issue, and it's just, they got lucky enough to overcome it. That's why it's a lot easier when there's DNA evidence. That's why with Steve's last case, I mean, much as they didn't want it to be true, they could demonstrably prove that Steve was innocent, and they had to let him go. With no DNA evidence to help, it's a really hard. But all the people I talked to, whether it talked to Jason Strong and talked to Eric Hosey and that they Daniel Villegas, who I've never gotten on yet, but I'm hoping still to get him on. They all won on non-DNA cases. So it can happen. But a lot of those cases that they already knew they were innocent when they first tried them, too. So still not talking about a very just cause. How should the statutes be changed? And ETPA? Why, you're asking me two different things, Travis. Which one do you want to know, about ETPA or about the piecemeal litigation? Oh, before I answer that, what I was saying before about the piecemeal litigation is that this is a very unusual circumstance. I think they even mentioned it again in my first 15 pages about how Kathleen should have waited until her investigation was complete. Like, you normally would file a petition for post-conviction relief after your investigation is complete so you can present all of your issues. Exactly when is KZ's investigation complete? Until Steve's out, it's not going to be complete. She's always going to be looking for new information. So how long is she supposed to wait? And that's why I say it's a really unique system. That ideally, yes, she should have waited until she'd had all of her information that she had. But how can you do that when you're getting new leads all the time? You have to start moving the case forward at some time, at some point. And every time that she filed, except for the first one, and this is again an issue that the state's not wrong about, is that she filed the first petition knowing she was going to add a supplement. That she shouldn't have done. That is not proper procedure. But when she filed the supplements, she thought she was done, and then all of a sudden something else would come on, and that and come up, and that's why, I mean, this was delayed a lot by Kathleen. Remember, it's not just been the state. This was delayed by Kathleen for like 2 years because of adding all these extra supplements and everything like that. But that's because things kept coming up, and it just got to the point where it's like, you have to move forward. You cannot just keep doing this. It's been 3 years in the appellate court. You need to move forward. But again, it's a very rare circumstance. That is not how things usually go, and that should be taken into account. It's not like she's trying to get away with different things. It's just that the situation has changed, and the state's not wrong when she said that her theories change and everything. It's not good for a case. It is not good because it does give the impression that you're just throwing everything at it, and it's not a sound legal position to do it that way. But again, she's in a very strange position. What else is she supposed to do? Because if she ignores things now, she's opening herself up to the procedural bar issue again. So she's really kind of stuck in between a rock and a hard place on some of this. Have people still coming in and out? Everybody tired of hearing me rant now? Anybody else have anything to add? I think I made the same point, and I know there's still things that I forgot, and I'm going to remember right after I log off probably. But I've been on for a while, I think. Close to an hour. And honestly, I might not even read this thing until till the reply comes out. And just look at it all together as one like cohesive unit so I can make more sense out of it. How many does Kathleen take on? She has a lot. She has a lot going on at the same time. She takes on several. She has a pretty large team. So, I mean, her team, will be doing a lot of the legwork on some of this stuff. And it is difficult because Kathleen does take on cases in different states. And I think that does hurt her a little bit because Wisconsin law is very different than Illinois law. And I think that did throw her off a little bit in the beginning. Because I know she did some mistakes early on that just because Wisconsin law is so different. And that's why you're supposed to have like local counsel, but I don't think her local counsel really is doing anything. He's there to sign his name, that's it. Yeah, that's why she has a supplement. She can't wait for everything. You can't. So I'm probably going to wrap it up unless anybody else has... Let's see, I got a message. there goes Justice Bark Bark. That's really good. Like when I talked to Ricky and his daughter a couple days ago, she barked the entire hour. I was ready to strangle her. Does anybody else have any questions on me? I'm getting kind of tired, actually. Oh, do you have the channel now, or for now, or is that just to your channel, or is that to the actual feed? That's their channel. Okay. So Fen just posted the 80 More Things channel. Join us Saturday night. I don't think we have a time yet. I know we were discussing, or there was being discussed right as I was going live, so I didn't get to put any input. But I honestly, I'm the house guest in that one, so I'm just gonna show up. I'll show up drunk and yeah, whatever. It's not my show. Just kidding. Well, I might actually show up drunk. We don't know. Yeah, it seems like I've dropped about 10 people, so I think people are tired of hearing from me, talking to me. I wonder if Jane fell asleep because she was supposed to be here and she is not. But it was like 2 a.m. for her. Night, Marilyn. Thanks for sticking with me for my double header. Thanks to everybody. I've had you for like 2 hours and 15 minutes, everybody that watched both. And again, if you missed the interview with Ricky and Jasmine, I think that people enjoy the interview. And that's really something that I'm happy to be focusing on right now, just because I can't do this legal stuff anymore. So doing these interviews with these wrongfully convicted and trying to do more work, more advocacy work, is something that I think is really going to be better for me right now than me trying to read all this stuff and do stuff that's really hard for me. Yeah, it used to be called Basically a Lawyer. I've rebranded it since I'm going to be talking about wrongful convictions to Scales of Injustice. So that's the Facebook group. I'm sure one of them can grab the link real quick. Yeah, they had me in tears there talking to Ricky. Every time Ricky gets choked up, I just start getting choked up. Oh, good. Well, thanks for joining me, Momtastic. That's really cool. But yeah, if you haven't hit the thumbs up button, I should have said this before. If you like the video, just hit the thumbs up. It's not even being monetized. I always forget to monetize these things. So, if you haven't subscribed, hit the subscribe button. And hit the little alarm if you want to get notified whenever I go live. Yeah, Paula, you have been here for both. Thank you. I really appreciate everybody that stuck through both of them. But I really wanted to get on to say something about this, even though I knew I couldn't talk about the actual brief too much. But I just don't think I'm going to need to. It's same thing over and over and over again, and it's disappointing. It's frustrating. It's angering. But yeah, I got more people dropping. So, but thanks to the 30 that are still here with me. Appreciate it. I know it's late. So anything else before I go? I'm going to wrap it up. Okay, I think that's it then. All right, thanks for joining me, and I will see you guys on Saturday at some point. We'll post in my group the time. Ben and Julia both be posting on Twitter and on their Facebook, so I'm sure you'll see it somewhere what time we're going to do this. So thanks for joining me, and everybody, I hope you have a good night. Bye.